for joining us today. Today we're going to be talking about eminent domain. It should, in the state of Georgia, we should only be talking here for about 30 minutes or so. And with that said, I won't waste any more time and we will go ahead and get into it. If you have questions as the presentation goes on, feel free to ask them. I might not address them immediately. It's possible my presentation will address them. But regardless, I will answer them if they are not already answered by the presentation itself. So again, with that being said, we'll go ahead and get started. Okay, so as you can see, again, what we're doing here today is talking about eminent domain in the state of Georgia. And before we get into that, I want to address just kind of an introductory preface. A lot of people are curious why they get letters from us, why they specifically received a letter from us. And what I tell people is that the reason why you got a letter from us is because at least right away has begun on at least a part of the project that ultimately affects your property. Meaning the DOT has already acquired some right of way on the project that we mailed to you for. What that means, what that tells us, is that they are in land acquisition, they are in right of way acquisition, and that tells us that it is timely to market to you folks. So that's why you got a letter. A lot of people also will ask me, well, I haven't received an offer. No one's contacted me from the DOT. You know, they're not, we're the first contact with anybody sometimes. And ultimately, you know, your property, if your property is affected, which we believe it is, you will receive that contact from the DOT. They have to reach out to you. They have to contact you. We'll get into what that process is and how they contact you here in a bit. But if they need your land, which we suspect they do based on the maps we've seen and the information we've gathered, they will come through. They will make their presence known. So that when people ask why they received a letter, that's what I tell them. Who we are eminent domain attorneys. This is the only area of practice that we do. It's the only area of practice that I do, that anyone else in the firm does. Not only that, we are only landowner attorneys. So there are condemnation attorneys that, of course, work for the condemnor, which is generally the state, the DOT. And then there are eminent domain attorneys that sometimes just work for landowners. Some of them do both. We only represent landowners. So we are here to help landowners exclusively. We do not work for the DOT. We do not work for any condemner. We haven't, and we don't plan on it anytime soon. Today, what we're going to be talking about is eminent domain, of course. We're going to share our experience that we have collected. We are a national law firm, but we obviously have an office in Georgia. I am the Georgia attorney at our firm. I'm the only attorney licensed in the state of Georgia at our firm. So even though we are a national firm, we do maintain a focus on certain states, and Georgia is one of those states. And of course, again, I am the attorney for our firm for Georgia. But because we're national, we've been able to accrue quite a bit of experience, not only in the state of Georgia, but in all the states we're licensed in, all the states we help landowners in. We've accrued all this experience involving any type of property you can imagine, any type of situation you can imagine, and that experience allows us to effectively represent landowners, and it allows us to teach you guys today what to expect. And we'll start with a simple concept. What is eminent domain? Eminent domain is the forced acquisition of your land for a public purpose. The most common exercise eminent domain is for road projects, as you may imagine. So basically, eminent domain ultimately means that if the DOT wants it, they will get it, and it being your land. You can say no at first, and you can continue to say no if you'd like, and we'll talk about what you can and can't do and what you're allowed to do. But ultimately, if the DOT follows the law, then they will ultimately, and they want it, they will ultimately get the property, barring them doing something untoward in the negotiations. But regardless, it's fair to assume that if they want it, they will get it. So what that means is it changes the negotiation dynamic between the landowner and the DOT. You're not selling it to your neighbor, you're selling it to the DOT, or rather, you're selling it to your neighbor who can take it effectively, and that changes the dynamic. It changes how you can negotiate. It's not a traditional arm's length transaction, and the cloud of eminent domain kind of hangs over the negotiations, which uh, usually put the landowner behind the eight ball. So in these negotiations, it's important for a landowner to kind of even the stakes, leverage your position, try to even the negotiation posture. Uh, so while they can take it under eminent domain, they do have to pay for it, and they don't just pay any old amount of money. You are entitled to just compensation, and your definition of just compensation is going to be different, very likely, than the DOT's definition of just compensation. And with that disagreement, um, comes the wiggle room, comes the arguments that you need to make to get to more compensation, get to the right amount of money. So in other words, just because the DOT says your land is worth $10,000 or whatever, uh, they aren't the arbiter. They don't determine what you're entitled to. They will if you don't fight it, but ultimately you are allowed the ability to contest this compensation. You are allowed to contest this compensation into court if you'd like to, and you have the ability to raise your voice effectively for more compensation. So while it's tough to stop these projects, it's pretty much impossible to stop these projects at the right of way phase. But it's much easier, it's much simpler, and it's built in the law to have a more even fight over compensation. That fight is much more different than the fight over their ability to take the land. So let's talk about the process in Georgia. And this is I've reduced this as much as possible to the basics for landowners, what to look for in the process. What I tell folks is the first time you are going to realize that A, they want your land, and B, they're going to issue an offer for it, is when you receive an appraisal letter. This is the first stage, the first step in any eminent domain acquisition in the state of Georgia is the appraisal letter. And the appraisal letter, and this is a requirement by law, that prior to any sort of eminent domain acquisition, the DOT has to appraise the property. And not only do they need to appraise the property, but they need to send you a letter that notifies you of their upcoming inspection of the property for the appraisal. So at some point, you'll receive a letter from an appraiser that's working for the DOT it'll basically say, we're inspecting the property on this date. You're allowed to be there if you'd like to. You don't need to be there. And we are performing the appraisal. So when you get that appraisal letter, you'll know that they are going to shortly thereafter appraise the property, and then after that, you will receive an offer based on that appraisal. And this is the second step. This is pre-eminent domain, I should say. This is all the appraisal letter and the offer and negotiations. These are all before the litigation. So they've done the appraisal, and then they've completed it. The next step is getting the offer. So after the appraisal is done, somebody from the DOT, a different contractor in all likelihood, will reach out to you to issue the offer based on the appraisal. This is where our firm gets involved. Once you have an offer from the DOT, you will know A, what they're offering, the money that they are seeking to propose to buy your property, and B, you'll know exactly what they're taking. And that's the first stage in the process. Well, you'll know exactly what they want, how much in right of way, how much in easement, how much in temporary easement. All of that will be contained in the offer itself. And once you get that, you have a case, so to speak. And again, that's where we generally get involved in the process. So once you receive the offer, there is sometimes negotiations between the landowner and the DOT. I can only speak on behalf of our firm. We generally engage in some negotiations with the DOT if they're fruitful, or if we feel they'll be fruitful. But let's say those negotiations break down, and a deal cannot be reached. The DOT is sticking to their number because it's based off an appraisal, and they refuse to negotiate with you, or they refuse to get you to where you need to be from a compensation perspective. What happens then? Well, the DOT needs the property. They need to get it. And so if a deal can't be reached, they will file a eminent domain lawsuit against you. And this is stage three, the litigation process. Um, Once you're at eminent domain, the DOT will file a lawsuit in the county where the property is located. They will serve you a copy of that petition. And effectively, that once you've been served, you're in eminent domain. It's important to remember that you absolutely have to respond to the complaint, the petition, the lawsuit, so to speak. You'll be served this petition. You'll have 30 days to respond, and you need to respond appropriately. If you don't, if you file your response outside of the 30 days, or you don't file the correct response within the 30 days, then it's possible that the case is then over. And that what that would mean is that the DOT would get the land and you would only get what was offered by DOT prior to the condemnation. So they'll go to the lawsuit, they'll say, we determined this property to be $20,000. And they filed their lawsuit and you got served and you waited 31 days to respond. You didn't respond, you didn't file your objections to the petition. What happens at that point? Well, at the 31st day, the case is over. Your compensation, your preliminary compensation becomes your final compensation. And that $20,000 that they initially offered you becomes what you get. And there is no going back. There's no fighting that. Once you don't meet that deadline, it is over. Your case is done. That's all to say that it's very important that if you're an eminent domain, you know what you're doing. And you have the right attorney in place to respond appropriately so that your case doesn't end before it gets started. So just keep that in mind, something to consider if your case moves towards eminent domain. Next, I want to talk about what to do once you get your offer from the DOT, because there's a lot of I'm not going to say tricks, but right-of-way agents do certain things, and it's important to you to I guess keep them in line, make sure they are issuing offers in written form, make sure that they aren't trying anything fast with you and that everything's on the up and up. And these are best practices for dealing with right-of-way agents when you get their offer. I tell folks, insist that the right-of-way agent communicates via email only, and that they send their offer packet via email in addition to regular mail. They're going to try to want to meet in person. They're going to want to set something up and do something in person doing things in person is effectively off the record. They can say more things that maybe aren't necessarily true, or maybe are partially true, or maybe are misleading, and all of these things kind of disappear because they're done verbally, and no one, it comes to he said, she said. So what I tell folks is that I like to keep things all on the record, as it were, and then so once you get your offer, if they decide to go in person and drop it off, say I want this mailed, I want this scanned to me, I want it emailed to me, I want all communication correspondence to go via email or text if you'd like to. What I tell people to tell folks is when you get that offer, they're going to want to talk, they're going to want to negotiate, and those are engaging in those types of negotiations with right-of-way agents is going to end up in a bad spot because they're going to press you, they're going to want you to say what you think your property's worth, they're going to want you to throw a number out without you even knowing the acquisition or knowing what's going to happen or all the possible consequences resulting from the acquisition. So back to best practices, what I say is either once you get the offer, hopefully via email, you email back, thank you, I will review this and get back to you in a week. I think that's a fair response because it shows the right-of-way agent that you're not just blowing them off, but you are also going to do your due diligence and not be pressured into a decision. And this keeps everybody at bay, at arm's length. It allows you to do your due diligence, to realize what your case is worth, and then respond in turn. You're not going to upset them by saying you want a week to think about it. They might seem upset, but it doesn't matter. You need at least a week to review it, to do your due diligence. They shouldn't have an issue with that. And this also allows you, this practice allows you to then contact an attorney in the interim once you've received the offer, get their evaluation, and then you'll have if you do respond, if you choose to respond, you'll have a comprehensive response, something that considers all the possible aspects and is done smartly and not just in a rushed manner. Again, avoid in-person discussions and negotiations, because I will say that when you do in-person negotiations, in-person discussions and negotiations, they will write everything you say down. You're probably not going to do that for what they say, but they're going to keep contemporaneous notes of your conversations, and those contemporaneous notes will stay with your file to the end of the acquisition, including it'll go to the attorneys, it'll go back home to GDOT, it'll stick with your file. And if you say anything in these discussions, they'll write it down, and then you may have revealed your hand in these discussions, and when you didn't really know what your hand was, and it can end up in a worse spot. Just something I don't generally recommend doing. So that's what you should do. What you should not do: do not engage in negotiations or discuss value without talking to an attorney. You are obviously free to negotiate. My recommendation is not to begin that until you talk to an attorney, because you could think you're coming from a position of strength, and that if they offer $5,000 and you come back at $30,000, then you're probably doing something right. But the reality is it could be much more than that. You could be doing yourself a disservice. There's no way of really knowing until you get a full evaluation of your offer that includes all the possible outcomes. What I tell folks is that doubling a terrible offer only makes it a bad offer. It doesn't make it a good one. So engaging in these types of negotiations before getting a full grasp of everything, before contacting an attorney, I do not recommend it. Do not enlist an appraiser until instructed to by an attorney, or the attorney will get it for you. This is because I don't like landowners to spend money they don't need to spend. Eminent domain appraisals are very expensive, and sometimes they're not even necessary. A lot of times we are able to resolve cases without having to go out and get an eminent domain appraisal. And if that is the case, if you go out and immediately get an eminent domain appraisal or get an appraisal, you might have been able to get to that point without that appraisal and without spending that money, because again, these are not cheap appraisals. And beyond that, you need to make sure, if you are spending that type of money, that what you're getting back is worth it. And that means getting somebody an appraiser who GDOT respects, who can testify on their value, has experience with eminent domain appraisals, knows how to do it, so on and so forth. So the point being, if you are getting an appraisal, you want to make sure, A, you absolutely need to get it, and B, what you're getting is worth it. What I tell folks is that I generally do not get appraisals for my clients, for my Georgia clients, unless the case is eminent domain. And even then, it's not always necessary. It's probably necessary at that point, but it isn't necessary. It isn't just because you're there doesn't mean you have to get it. So in any event, I don't like clients, especially landowners in these situations, spending more than they need to. That would be an example of doing that. It would be going out and getting that appraisal, potentially. Do not meet in person with the right-of-way agent. This is what they want to do. I do not recommend it. Do not make a rush decision. That goes part and parcel with meeting in person and making a quick, rash decision. Do not recommend doing that. I do not. But I also, in the same vein, I do not recommend ignoring it altogether. One thing that happens with folks is they kind of let this fall by the wayside, or they ignore it, or the offer is issued and they forget about it. Don't be one of those people that gets the offer, puts it aside, doesn't think about it again. All of a sudden, you're in eminent domain, and you might not want to be there. So it's important that when you get that offer, the easiest thing to do is just send it to me, for example. Send it to an attorney. I look at offers for free. I will look at all of your offers for free as soon as you get them. And I can get back to you. I can analyze an offer within a day, and give you my thoughts on what I think you should be doing. And then you can decide what to do. So that would be, I think, the easy advice to avoid all of these potential pitfalls with the DOT is, as soon as you get the offer, tell them to get back to them in a week. Contact me, send me your offer. I'll look at it, and you can then decide what you'd like to do. Okay, and we're going to get into, these are the compensation figures, and then we'll be about wrapping up. Okay, So there's going to be three cases or three keys to your case if you have a partial acquisition. Partial acquisition, as you may surmise, is an acquisition of only part of your property. If you have a 2-acre parcel and they're acquiring a third of an acre, that is a partial acquisition. So for partial acquisitions where they're leaving a remnant, there are three keys that you should look for. First, the value of the land. You should value it on a price per acre, price per square foot basis. And this is the underlying value of the property itself. It's important to remember, and on my second note there, I note that highest and best use is a portion of valuing the acquisition. Highest and best use is an appraisal term to describe the highest and best use of the property that brings basically the most value to the property. An example, sometimes, for example, properties are not put to their highest and best use. An example of this would be if you have a residence that is completely surrounded by commercial development. Maybe it's it's a house in a downtown area that's been developed, that's maybe older, that's been developed around, but it's still being used as a residence, even though that's the interim or current use. The highest and best use of that parcel could be commercial, and that would allow you a higher property valuation argument to make if that's the case. Determining the value of the acquisition, experts are pivotal, just like they are with every other claim that you can make. Usually, appraisal experts, if necessary, they come into play. But they are the ones that are going to be the ones that come up with your testimony. Ultimately, if you go to trial, are the appraisal experts that you get. So the value of the acquisition, that's obviously important. The second part for a partial taking is remainder damage. And this is a easy word for any impact that the remnant sustains, the rest of the parcel, because of the acquisition itself. So if you have you have a 2-acre tract, they're taking a third of an acre. First you have to determine what is that third of an acre worth. But then you also need to determine what the other 1.7 acres, how those 1.7 acres are affected by the loss of that third. And for residential cases, generally the categories for remainder damage for residential properties is setback loss. Basically, your home is closer to the road, you lose setback, as it's called, and your house consequently loses value. That is a big, pretty much the primary source of remainder damage for residential properties. The second one would be ordinance noncompliance, and that would be usually, again, tied to setback. If your setback falls below the county mandated ordinance for setback requirements, that can also cause an impact of value. For commercial, the types of remainder damage are much, there are many more types of categories. Ordinance noncompliance comes into play. Access limitation is a gigantic one. Losing access points cause huge impacts on commercial properties, and they are something that are generally not properly compensated by the DOT. Loss of visibility, reduced parking is another, probably the second biggest impact for commercial properties that we see, mainly because the parking is usually along the road that's widened. That's a big one. And if you can't replicate that parking, that can cause huge issues. If the property gets too small, if you lose your sign, if your highest and best use changes, if the configuration of the property no longer makes sense, these are all things that fall underneath the remainder damage umbrella, and they are arguments that you can certainly make. And then business losses. Business losses applies, to any business on the property. That means commercial or residence, as long as it is a business. For residences, that's generally a landlord-tenant situation, but for other businesses as well. And mainly, this is a commercial property argument, but the argument is such that if you sustain a business loss as a consequence of the acquisition, then you could be entitled to business losses. It's important to note that though business losses are compensable under the law, most condemners in the state of Georgia that we deal with don't acknowledge them and do not offer them. These are things that you are going to have to argue yourself. You're going to have to raise the issue. It's just a matter of course that they do not offer them. So it's important that you raise your voice and you raise this issue, because the DOT will not do it. And then for a total acquisition, there's a lot of similarities. The value of the acquisition, the first key to your case, what's the value of the property? And this, of course, is a total take, a total acquisition. The entirety of the parcel is being acquired. So what are the keys with that type of acquisition? The first is the same as partial. What's the value of the property? What is it ultimately? What's the highest and best use? What is the value? And because there's no remnant in a total taking, that's not a relevant consideration. But what is still relevant is business losses. And they are even more relevant, I think, for total takings because it's undeniable that that a business is generally shut down if it's a total acquisition. Now, so this is a big issue. It's something that if you have a total taking, you have a business, again, they're not going to offer it. You're going to have to raise it. And then finally, the third key for total acquisition would be relocation benefits. And this again is for total takings, and that's in total takings that include an improvement or a business, or basically a residence or a business. If it's a residence, you are entitled to moving expenses, but you're also entitled to a differential payment, and that can be significant. The differential payment is the difference between the value of your home and the available homes on the market. And DOT is not very good at this. They do not generally offer a proper differential payment. So it's something that you're entitled to. And it's important to note that the differential payment is a non taxable sum. And involving an attorney in these negotiations can sometimes allow for, I guess, strategic negotiations to allow for a lessened taxable impact than you would otherwise realize. So keep that in mind if you have a residential relocation. Commercial relocation, you do not get a differential payment. You get the moving expenses and you get reestablishment expenses. And no differential. You basically get what it costs to move that business somewhere else without buying. You don't get money for buying the new property. Okay, and then these are my last two slides, and then we will open it up for questions. One of the big questions I also get is how can I afford an attorney? I can't speak for other attorneys. I can't speak for other counsel, but our firm operates on a contingency fee basis. There are no upfront costs. There is no retainer fee. There's no money exchanged until the case is resolved. So, for example, if you have an offer and you want to hire me, all you would need to do, and assuming we also would like to be your attorney, all you need to do is send me your offer. I look at it, give you a call, shoot you an email, give you a text, let you know my thoughts on it, and say, either yes, we'd like to take on the case, no, we wouldn't. And then if you want to proceed, you send me your email, I send you a contract, you sign, and we're off and running. You don't need to send me a check, you don't need to do anything like that. It's a pretty harmless process. What I'll say, a very easy example of our standard contingency fee that we offer. If you're offered $10,000 and then you hire our firm and then we get, for example, $100,000, this is an example, our fee would be 1/3 of the 90 that we add to the case. Let's say, for example, you hire us at 10,000, we don't get you another dime. What happens then? Then I don't get paid. Simple enough, fair enough. That also prevents, that allows us, or should inform you rather, that we don't just take any case off the street. If we take on your case, it's because we believe there's some real money there and the offer is not sufficient. And we've gotten, obviously, I believe we've gotten much better at, gotten good at identifying these bad offers and knowing where how they're insufficient, how they're deficient. So if we tell you that the offer is bad, there's a very good chance that the offer is not very good. And then finally, these are, I like to reiterate that while we do have a lot of knowledge, we have a lot of experience, ultimately, I don't judge our firm on how much we know or how many cases we have. I judge it based on what type of results we get for landowners. These are some examples of results we've gotten. These are not guarantees of success. I'm not saying that if you have a $15,000 offer that we're going to get you $3 million. The purpose of this slide is to, provide examples of how wrong the DOT can be with their offers and how inaccurate and insufficient they can be. And that, if you get an offer for $623,000, that seems like a lot of money, but it's possible that you could be entitled to double that or even more. and only somebody who knows what they're looking at can identify those types of cases and bring them to success. So again, these are just some results that we've had recently. We have plenty more on our website if you want to take a look at that. But again, just some results that we like to share with our potential clients. So moving forward, what I tell folks is if you have an offer, um, that is the time to hire an attorney. If you don't have an offer yet, what I tell people is, okay, you should start thinking about hiring an attorney. So maybe you got that appraisal letter, you're not sure what to do. That time period from getting the appraisal letter and getting the offer, that's when you maybe do some vetting of attorneys, see who you're going to hire, if anybody. And then when you get the offer, that's ultimately when you should hire somebody. Do not rush into a quick decision. Quick decisions are usually not good ones, usually result in insufficient compensation. Don't be pressured and rushed into a decision by the DOT. If you can get a group together, this is not a requirement. This is a suggestion, if possible, with your neighbors. Uh, for example, if you come to me with three of your neighbors and say we all want to go with you, and all of the offers are insufficient, we feel like there's money for everybody there. That may allow for a reduction on attorney's fees. Finally, there's only one chance. Once you sign the paperwork, it's over, it's done. There's no going back. So it's imperative that whatever you're signing, you're doing your due diligence, you're being responsible, you're getting second opinions, you're getting, evaluations objectively, so that you make the most of that one chance that you have at getting just compensation. And then finally, that is my phone number. That is my email address. Please do not hesitate to contact me. 470-869-1383 is my phone number. Jordan at landownerattorneys.com. That is my email address. Please don't hesitate to contact me with questions, shoot me a text. And again, feel free to send me your offer if you have it. We review those for free. You will not get billed if you send me an offer. What you will get is a response from me on what I think about it and what I think you should do. So with that being said, I'm going to stop sharing and I'm going to check out the Q&As because we do have one. Okay. There was a question that was asked. If the DOT acquires my business by end of June, will I get the money they initially offered? And am I allowed to accept that sum if I want to go to court? Worried about covering living expenses when I no longer have my business or income. So if they acquire your business by the end of June, either one of two things has happened. Either you have agreed to sell the property to the DOT without going eminent domain, in which case you would have the money in hand that they had offered. You get it when you close with the DOT, and you'll have that money basically simultaneous that you convey the property. So if you've reached an agreement with the DOT, then you'll get the money immediately. If, for example, you don't reach an agreement and they need to go to eminent domain, the way it works, they file the lawsuit, like I said, in the county where the property is located, but also with the lawsuit, they also deposit that initial offer with the petition with the court. So they'll file the lawsuit. Let's say they offered you $30,000 initially. They'll file the lawsuit. They'll deposit that $30,000 with the court that you, as the landowner, are allowed to withdraw through the eminent domain process. So they'll file the lawsuit. They'll deposit the 30. You can then appear in the lawsuit and disagree with the 30, but still be able to withdraw it to do with it what you need. So the initial offer is going to always be there, whether it's during negotiations or it's at condemnation. That you'll be able to get the access to that money in exchange for the property, whether it's at eminent domain or in private negotiations. Okay. Are there any other questions that anyone has? Okay. I do not see any other questions. Okay, well, with that being said, since there are no questions, I'll go ahead and wrap it up. Thank you for stopping by today. We appreciate it. Don't hesitate to contact me, 470-869-1383, Jordan at landownerattorneys.com. Happy to talk with you, and thanks for stopping by, and good luck.